On September 10th, 1782, the Congress approved, this is a quote, and recommended to the people the Holy Bible printed by Robert Aiken of Philadelphia. A neat edition of the Holy Scriptures for the use of schools. So the Congress of the United States in September 10th, 1782 is saying the schools in the United States need to use this edition of the Holy Bible. Another point, the delegates to the Constitutional Convention had already taken an oath to their own state constitutions. Every state constitution in the United States by 1787 mandated that every elected official in that state had to swear to a belief in the Holy Trinity. You could not hold office unless you were a Christian, unless you believed in the Holy Trinity and believed in the Scriptures. Now, unless they were committed to being Christians, they could not have been delegates to the Constitutional Convention in the first place. They couldn't even have gotten there. Does it make any sense to you that those Christian men sitting there in the Constitutional Convention are going to create a constitution that says it doesn't matter if you're a Christian? Their state constitutions had sworn them to Christian faith. They had taken an oath to uphold the Christian faith. We would find some evidence in the constitutions or laws of their various states about this separation of church and state thing. It would be in their state constitutions. If the present day ideas about the separation of church and state had been in the minds of the founding fathers in the Constitutional Convention, we would have found some evidence of that in these state constitutions they had just taken oaths to uphold. There's no such evidence. To the contrary, all of those state constitutions, with no exceptions, require that you have to be a believer in the Holy Trinity to hold office. This doesn't make any sense. Those men would never have created a constitution that separated church and state. They'd come from states where obviously the exact opposite was the case. Now, is there evidence since the founding to refute all this nonsense? You bet your life. Supreme Court, Holy Trinity versus U.S., 1892, quote, "No purpose of action against religion can be imputed to any legislation, state or national, because this is a religious people. Our laws and institutions must necessarily be based upon the teachings of the Redeemer of mankind." Do you hear that? This is the Supreme Court of the United States, 1892. Our laws and institutions must necessarily be based upon the teachings of the Redeemer of mankind. It is impossible that it should be otherwise. And in this sense and to this extent, our civilization and our institutions are emphatically Christian. This is historically true. From the discovery of this continent to the present hour, there is a single voice making this affirmation that this is a Christian nation. We are founded to legislate, propagate, and secure Christianity. That's the Supreme Court, 1892. And they say they can't find any precedent to uphold the idea that America is a Christian nation. In the Abner Updegraff case of 1824 in Pennsylvania, Abner Updegraff was arrested, tried, and convicted of blasphemy in the state of Pennsylvania because he said the Scriptures were a mere fable. The Supreme Court of Pennsylvania upheld his conviction, and even his defense lawyers, who used the First Amendment arguments of freedom of speech that everybody uses today. That's the only defense they could find for Abner Updegraff. But his defense lawyers publicly stated in the court that that he was wrong in what he said, that it was scandalous that he had said it, that they were very upset with what he had said, but they would give him a good defense anyway because every citizen is entitled to one. But his defense lawyers wanted to go on record with the court as saying that personally they were horrified at what he had said. And he was convicted, and his conviction was upheld, convicted for blasphemy. Now that shows you the strong Christian consensus in America. You know, as late as the 1820s, it was there all right. People versus Ruggles, state from the case from the Supreme Court of New York State. The Chief Justice of the New York State Supreme Court, Kent, noting in this case that this case assumes, quote, that we Americans are a Christian people and the morality of the country is deeply engrafted on Christianity. 1952, you get real up to date. Zorak versus Clausen. The United States Supreme Court said, quote, this is the William O. Douglas Court, quote, we are a religious people whose institutions presuppose a supreme being. When the state encourages religious instruction or cooperates with the religious authorities by adjusting the schedule of public events to sectarian needs, it follows the best of our traditions. 1952. The New York Spectator newspaper of August 23rd, 1831, reported from the Court of Common Pleas of Chester County, New York, that a witness was rejected from testifying in the court case because he declared his disbelief in God. The presiding judge remarked, quote, this belief constitutes the sanction of testimonies in a court of justice, that he knew of no cause in a Christian country where a witness had been permitted to testify without belief in God. Justice Joseph Story of the United States Supreme Court, who knew many of the Founding Fathers, was a close personal friend of Chief Justice John Marshall, wrote his famous Commentaries on the Constitution in 1833. Now, this was absolute, mandated, required reading for every law student in America up until very recently. Justice Story, famous Supreme Court justice. Quote, listen to this. I've got two more quotes from you. This from him, from Justice Story, Joseph Story, and Chief Justice Rehnquist in today's court. And we're almost through here. Quote, we are not to attribute this prohibition of a national religious establishment in the First Amendment to an indifference to religion in general, and especially to Christianity, which none could hold in more reverence than the framers of the Constitution. Probably at the time of the adoption of the Constitution and of the amendments to it, the general, if not universal sentiment in America was that Christianity ought to receive encouragement from the state. Any attempt to level all religions and make it a matter of state policy to hold all in utter indifference would have created universal disapprobation, if not universal indignation. It yet remains a problem to be solved in human affairs, whether any free government can be permanent, where the public worship of God and the support of religion constitute no part of the policy or the duty of the state in any recognizable shape. And here's Chief Justice Rehnquist. This is from the recent Alabama court case, I think 1 or 2 years ago. Present Chief Justice of the United States Supreme Court. Quote, thank God for him. There is simply no historical foundation for the proposition that the framers intended to build a wall of separation. There is overwhelming evidence that all the founders meant by that was that we not establish a national church as was found in England. There is statement after statement, even from the constitutional notes themselves and all sorts of other people who were involved with it, that this is what was meant. It is impossible to build sound constitutional doctrine upon a mistaken understanding of constitutional history. The wall of separation between church and state is a metaphor based on bad history. A metaphor which has proved useless as a guide to judging. It should be frankly and explicitly abandoned. He goes on to point out that the first Congress that passed the Bill of Rights also passed the first public declaration of thanksgiving and prayer. This was done the very same day they approved and set up the First Amendment. Now, they had quite a day. They passed the Northwest Ordinance, they passed the First Amendment, they passed a declaration of a day of prayer and thanksgiving. And George Washington declared this day at the request of both the Senate and the House. And Washington said, quote, a day of public thanksgiving and prayers to be observed by acknowledging with grateful hearts the many and signal favors of Almighty God. Rehnquist concludes, history must judge whether it was the father of our country, Washington, plus the majority of the House of Representatives and the Senate who were correct in their understanding of the First Amendment, or whether it is a majority of the court today. The problem is the courts become a law unto itself. Abraham Lincoln: I do not forget the position assumed by some that constitutional questions are to be decided by the Supreme Court. At the same time, the candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made, the people will have ceased to be their own rulers, having resigned their government into the hands of that eminent tribunal. That's what's been happening to us. Lastly, a quote from Richard John Newhouse. We are two nations, one concentrated on rights and laws, the other on rights and wrongs. One radically individualistic, dedicated to the actualized self. Got to do what's best for me. The other communal and invoking the common good. One viewing law as the instrument of the will to power and license, the other affirming an objective moral order reflected in a constitution to which we are obliged. One given to private satisfaction, the other to familial responsibility. One typically secular, the other typically religious. One elitist, the other populist. No other question cuts so close to the heart of the culture wars as the question of abortion. The abortion debate is about more than abortion. It is about the nature of human life and community. It is about whether rights are the product of human assertion or the gift of nature and nature's God. It is about euthanasia, eugenic engineering, and the protection of the radically handicapped. In the 1992 Casey decision of the U.S. Supreme Court last year, liberty is no longer the ordered liberty of the founders, nor is it liberty directed to the good and formed by communities of memory and obligation. According to the court, liberty is now the liberty of self-will, self-expression, and self-constitution. Selfish is exactly right, son. Against alternative understandings of the self in relation to community, normative truth, and even revelation, the court recognizes no other reality these days than the isolated individual defining his or her reality. We've lost our sense of covenant and community. That's what I've been teaching you all week. All of this means that the only hope for America is the recovery of our basic Judeo-Christian moral and spiritual foundations.